sometimes feel like a lot, but you don't have to do it alone. I strongly believe that we're stronger together. Here, we're going to slow down, have real talks, make sense of things together, and explore ways to intentionally grow the life you want. We're going to talk about mental and physical health, relationships, money, work, and community. Welcome to Rooted in Intention with me, Karina Gomez. Hi, everyone. Thank you for tuning in to another episode. I know there's a lot happening in the world right now, especially with the ICE raids and the National Guard presence. It might feel scarier and overwhelming being and even just existing in many of our communities, our homes, at work, or even at school. And maybe you're concerned about what could happen to you, a family member, or other loved one while you're going on about your day. And those are very real concerns. And I also know that part of that fear sometimes comes from not knowing what to do in situations that we haven't found ourselves in before. And that's why education is one of our strongest tools, because with education, we can at least feel a little bit more prepared to help us navigate some of those what if scenarios. And there's a lot of information to keep up with out there, especially on social media. So today we're going to bring some of that together so you can feel a little bit more prepared if you do have an encounter with an ICE agent, police officer, or any other type of officer, either you yourself or within your community. And today I'm joined by a special guest, Leasly Salazar, who is an Immigrant Justice Core Fellow at the Public Law Center, which is a nonprofit that provides free legal services in Orange County. So, Leasly, thank you so much for joining me today. And to get us started, can you run us through some of the top things that people need to know about their rights?
Yes, of course. Thank you, Karina, for having me. Yeah, so I am at Public Law Center, and like you said, we are a nonprofit organization that provides low-income residents of Orange County with free legal services. We have a variety of different areas of practice, and I can share more information about our areas of practice later. But yeah, I would say some of the more important things for people to know in terms of their constitutional rights that they should absolutely keep in mind is first and foremost, everyone, regardless of your status, it has the right to remain silent in any kind of situation. Really, the thought process behind this, and just to have for people to have in mind, is the less information you provide, the less information they have of you and that they can use against you. So really the most important right, I would say, that they can keep in mind is the right to remain silent. They can exercise that right in any scenario. If they can't remember the actual wording of it, they can just remember to say, I'm exercising the right to remain silent, or I don't want to say anything more. Another right that they absolutely can exercise is the right against unreasonable searches and seizures. So unless either police, law enforcement, or ICE has a valid warrant, we can get into that a little more later. Everyone has the right to be protected against unreasonable searches and seizures. They also have the right to refuse to sign any documents. They do not have to sign anything that is put in front of them. A lot of these ICE agents, a lot of these law enforcement agencies will use intimidation tactics or some kind of language to get people to sign these documents without really looking at what they are. They might say, if you sign this, hey, we'll let you go. But really, everyone has the right to refuse to sign anything unless they are able to see an attorney. They also have the right to refuse to give give documents except in certain scenarios. For example, if a person is pulled over while driving, they do have to be able to show identification and valid proof of insurance, maybe car registration, and a valid driver's license. There are select scenarios where they do have to provide documentation, but in general, they do have the right to refuse to give any documents. Also, another very important right that people have is the right to refuse access to their homes. The phrase that comes into mind is your home is your fortress, your castle. You have every right to defend it and to be protected within your own home. So unless, again, there is a valid search or a valid arrest warrant, everyone has the right to deny entry into their home. And that's something that everyone in your household should be aware of, because with one person opening the door, that allows them to come into your home. So as long as everyone in your home is aware that you have the right to deny entry, then you can remain safe in your home. Again, unless there's a valid judicial warrant. And also that everyone does have a right to an immigration attorney. It's not the same as in civil and criminal matters where everyone has a right to have an attorney appointed to them at no cost. Within immigration field, you do have the right to an immigration attorney at your own cost, but it is still a right that you do have. So I would say it might be a lot to have to keep in mind when thinking of all these rights, but in any given scenario, in any circumstance, the right to remain silent, the right to deny entry into your home, and the right to refuse to sign documents, I think are very important ones to keep in mind, and that can be very helpful in any kind of situation.
Mm. Thank you for sharing that high level overview. And I know one of the things that I usually find helpful is thinking about possible scenarios and what that can look like. Can we maybe start off with, say, someone is pulled over? What do those rights look like in real life? What can they possibly look like?
Yes. So what that can look like if, for example, someone is being pulled over by ICE or law enforcement, we do know that that has come up where people might be pulled over while driving. Generally, what can come up in those situations, they'll ask for your driver's license, insurance, and registration. We definitely recommend everyone be driving with a valid driver's license. We do have the ability, at least here in California, for AB 60 licenses. So even if you do not have legal status, legal documentation, you are able to obtain an AB 60 license. And that does allow you to at least be able to drive with a valid license. We recommend everyone be driving with at least the AB 60 license if they can get one, or an actual California valid driver's license to minimize any risk of a negative encounter,
Mm.
minimize the risk of a citation for driving without a license. Right. So they will definitely ask for some form of documentation in that sense. At most, that is all that they should be able to provide is just your driver's license, insurance, and proof of registration. They should also remain in their car with their hands on the steering wheel. So try to minimize any kind of negative encounter with them. It's likely going to be a high stress situation, the fact that you are being pulled over and being questioned. So at best, just it's easier said than done, but to remain calm and collected and just listen to what it is that they are saying and comply with every reasonable order that they do provide. In that sense, they will ask for the driver's license, but do not provide any other type of foreign identification. It can come up that some people will say, well, I only have like a matricula, a consular ID from their home country. Again, if they are not able to have an AB 60 license, I understand the need to have some type of documentation on you. At most, minimize the ability to share that kind of information, because sharing any type of foreign identification will put these officers on alert that maybe you don't have status. Why is it that you only have a foreign documentary identification card, whereas some kind of state ID card or state license? But in those circumstances, only show that very specific type of information. Don't provide any other type of documentation unless for some reason you are being asked for that. But yes, don't willingly give any kind of foreign documentation or any proof of a pending immigration application. I know there might be information going around of having some kind of proof, but withhold yourself from providing that unless you're actually asked. Also, what might come up in those scenarios when you are pulled over, they might actually ask for identification from your passengers. That's actually a very important thing to distinguish. The driver is supposed to provide documentation and identification for themselves, but the passengers actually have a right to not give any identification. So in those circumstances, if an ICE agent is asked, hey, I want your identification, the passenger can say, I'm a passenger and do not wish to give my ID. And they can choose to remain silent as well, exercising that right to remain silent. So, what can happen if in that moment you are stopped and you are pulled over? You can ask the officer, why am I being stopped? And they might say what it is that they're doing or what it is that they're looking for. You can also ask, am I free to go? This can go in one of two ways, really. They can say, yeah, sure, you can go, and you can just drive away calmly and slowly and safely. It might come up that no, we need to ask you something or we need to get this information. You also can choose in that moment to say, actually not say anything. You can say, I choose to remain silent. And if, there's resources out there for something called the red card, which is a little small card that has your rights listed on them and what you can do in certain situations, you can give the officer that red card in that moment. If they say no, you are not free to go, you can also ask if they have a warrant, if they are trying to arrest you or search your car. They have to be able to have some kind of valid warrant unless there's some reasonable suspicion that you violated some kind of traffic violation or something in order to search your car. But if none of that happened, if they never said why it is that they pulled you over, you can ask if they have a warrant. And a warrant should be signed by a judge or magistrate. It can't just say, officer or supervisor or anything like that. Anything that's signaling that some agent within the ICE office signed it. And it should detail specifically who it is that they are looking for or what it is that they're searching for. It should say that it is coming from a court of some kind, and basically articulate what it is specifically that they're looking for or who they're looking for. And if it says someone else's name and does not have your name, you can say in the moment, this is not me. This is not my name on this document. I do not wish to be searched or for you to keep questioning me. And in that, the officer may disagree in that moment. The most important thing to keep in mind is to remain calm as much as possible. It's going to be very difficult, understandably, because it would be a high stress situation. But at best, if you can remain calm and say, this is not me, this is not who my name on this document, I wish to remain silent. At some moment, they might ask for you to get out of your car. You should comply calmly. It might be that they are not doing something unlawful, unfortunately. But at best, the best thing that you can do in those scenarios is minimize any kind of negative interaction against you. So comply as best you can with their orders. Do not interfere if they choose to search your vehicle, but definitely keep note of all of these details in this interaction, because if they are doing all this without that proper warrant or without a reasonable suspicion, or they are not articulating why it is that they're looking into your car or anything like that, you should make a detailed note of all of these actions so that in the future, hopefully it doesn't come to that, but you can use those facts to help your case, your situation, should it get to the point where you are arrested. And in whatever scenario comes up when they are pulled over, like I said, they all have the right to remain silent. So whether or not they make them get out of the car, you can still exercise your right to remain silent, and give the officers the red card, whether or not you are arrested. So being pulled over can definitely be very stressful, and trying to figure out how to best navigate that situation. But at the best responses or the best advice that we can give really is for them to remain calm, provide the requested documentation, which is your driver's license, registration, and car insurance, and ask, are you free to go? Am I being arrested? Why am I being stopped? And complying with their orders should they order you to get out of your car, and not interfere in any kind of circumstance to best avoid any kind of further escalation of that stop.
And for those people that might be living near border towns or traveling near border towns, I imagine that there's a lot more checkpoints from border officers. How would those potentially look different, if at all?
Yes, so just to kind of give a bit more background information, checkpoints generally do apply within 100 miles of the border. So as you can imagine, a lot of LA County, a lot of Orange County fall within the scope of those 100 miles. So there's definitely going to be a lot more increased ICE presence and Custom and Border Protection or CBP presence. And it really depends on those checkpoints. What can happen is proceed as calmly as you can through those checkpoints. They usually might ask, do you carry any agriculture or any foods? They might ask for citizenship. I personally have not had that come across too often, but it's been years since that has happened. The most common checkpoint that I am familiar with is the one in San Clemente in California. And in my experience in driving within that area, generally they don't tend to stop people all that much unless there's something going on or there's more inspection. But for the most part, what I have seen is they might just be able to drive through with no issues. But in those kinds of scenarios, the same rights still apply. Provide your identification if that is what they're asking for, ask why you are being stopped, if you are free to leave, and exercising your right to remain silent at all times possible.
So, what type of documentation is required to provide within a checkpoint? I know I've heard information about people wanting to carry their passport to show proof of documentation. What are the things that would be helpful to be carrying around?
Yes, so to give a bit more information, previously within these checkpoints, the purpose of CBP, Customs and Border Protection, was to inspect and detain anyone who entered the United States within 2 weeks of their entry and put them through what is considered expedited removal. So expedited removal is someone's going to go through deportation proceedings without appearing before a judge unless they express a fear of return to their country, at which point then they can argue the case before an immigration judge. And this type of exercising of inspection and surveillance only applied within 100 miles of the border. With this new administration, things have changed, and so now they are applying this throughout the whole country, and it expanded to beyond the 2 weeks, so anything within 2 years. And the reason I mentioned the 2 years is because what they are exercising at this point is putting people in detention, detaining people if they have been in the country for less than 2 years. Now, what that would mean for individuals is what documentation to have on your person. If they have been in the United States for longer than 2 years, having some kind of either a utility bill or some kind of document that has a date stamp on it that would show that they've been here for longer than 2 years. So something that can be easy to have on you would be, for example, your identification card of some kind of state ID that'll have a date of issuance and a date of expiration, and it might well be more than the 2 years. The car registration, for example, if you are driving and the car registration is dated from over 2 years ago, that can also help as some type of documentation. So any kind of document that can be date stamped, really, a receipt or some kind, we would recommend carrying that on your person. In terms of what kind of other documentation to have on your person to show status, generally for individuals, for example, who are lawful permanent residents or green card holders, more commonly known, the law actually states that they do have to carry their green card on them at all times. Understandably, with the current administration, there is fear of, what happens if I lose this card. At What we do recommend is if you can have it on you, or at the very least having a photocopy of your green card on you. Individuals who don't have a green card but might have what are called employment authorization documents or work permits, EADs as they're more commonly known, having that or the photocopy of it on you, any kind of document that would show that you have some kind of action pending on your case. If you have a pending immigration case that is dated from over 2 years ago, having that type of receipt notice on you and also showing that, you have something pending with U.S. Citizenship and Immigration Services, commonly known as USCIS. But again, any type of receipt notice, any type of pending application notification, I would not show that information unless asked
Mm.
about your status or anything like that, just to minimize the risk of any further escalation of interaction. Passports, understandably, that can be very scary to have on your person, especially if you are, for example, a US citizen. Having maybe the photocopy of the demographic, biographic information on you, or better yet, if you have, for example, the passport card, having that on you as well. Something that can maybe help as well is if you do have a real ID, that can also be helpful. I know for a lot of individuals who don't have legal status, some of them may be able to get a real ID. Some individuals are able to get that, and that can also help to show, you have something available for you. It might still say federal limits apply on the ID or on the driver's license, but anything that shows any type of documentation that was either issued by the US or by the state is preferable over any type of foreign document. For example, your passport from your home country, or a consular ID or matriculate ID, as it might be known. If that's the only type of documentation you have, any type of identity document, understandably, that'll be the only type of document that you'll have on your person. But we recommend only showing it if that is really the only other type of identification document that you have available.
Okay. So for someone that might have DACA status, for instance, what would those documents preferably be?
Preferably for someone who has DACA, ideally they would have either obtained a state ID or a California driver's license. That would be the best thing to have on your person, as well as the work permit, just to help balance it out. Because the state ID or the California driver's license, or state driver's license, really, it might not indicate clearly whether or not you have status. I know for some people, if they were able to get the real ID, either for the license or for the state ID, it'll have the little star, or it might still have some kind of notation that there's still federal limitations on it. So ideally, having on their person the state ID or the state license backed with their work permit, that will showcase that, they have DACA, but they still have a valid form of identification from the state.
Okay. Thank you for sharing those. And switching gears a little bit to another potential scenario is having encounter with officers when you might be at home or at school. Can you walk us through what that could potentially look like and how people could implement the rights that you shared earlier?
Yes, of course. I think the first scenario that I can give some information on is what to do if ICE does come to your home, because that can definitely happen. First and foremost, what an individual should do is, again, I've said it before, and I understand it would be a very stressful situation, but remain calm as much as possible. And absolutely keeping the door closed at all times. The moment you open the door, you are providing an invitation for ICE to be able to enter your home. So should they come, what might happen is they'll probably knock on the door. They might not necessarily identify themselves. So ask who it is, ask what it is that they're looking for without opening the door. What might come up in these scenarios is the officer might say, oh, we're doing some surveillance, just wanted to ask you some questions. Can you come out and answer some questions? They might use certain language, certain questions to essentially lure people out so that they can exit their home and be able to interact with them. In that moment, what people should absolutely do is stay inside, keep their door closed, and ask them, do you have a warrant? And what might come up in that moment is they might say like, oh yeah, here's the warrant, and they just show it very briefly. Might maybe by putting up to the window or by the keyhole, or if people have like smart cameras, putting it by the doorbell camera. And you can absolutely request an amendment. No, I would like to inspect it. Either they can slide it under the door or hold it up a little more clearly. And this is where knowing how to identify a valid judicial warrant comes into play. So I mentioned it briefly, but I do want to specify and be more clear on what a valid judicial warrant looks like. A judicial warrant, if you can think of the things to look out for, should say court at the very top, that it's coming from some type of court, with either within the state of California or within the judicial district that it's coming from. It should also say who it is that they're looking for, what address they're looking for the date and time that they're looking to execute that warrant. And most importantly, it should be signed by a judge or a magistrate. So the document should have a signature, and the title of the person should say honorable judge or magistrate, some type of identification that it is a judge. For most of the time, what a lot of these ICE officers might be presenting is a document that'll say like order for removal or order for deportation. And it'll just have the person's name, but it won't necessarily have an address. And it'll say it's signed by officer, supervisor, or some type of other title, not no title that'll say judge or magistrate or honorable. And that should indicate this is not a judicial warrant. The basis for a judicial warrant is that this person had to go, this person that wants to execute this officer went to a judge and stated with particularity why it is that they're looking, what's their reasoning. There's a certain standard that they have to reach, and they basically have to argue that what it is that they're trying to do is valid. And so the judge will either have to agree to it or not agree to it. Whereas with an order for removal, order for arrest, for removal, it could really be signed by anyone within the department. So what people should look out for is that the document says that it's coming from a court, that it lists the information very in detailed format, like when, where it's being executed, what time, who is being arrested, or what is being searched, and that it's signed by a judge. And so in that moment, if you see this is not a valid warrant, it doesn't say any of those identified things, then that person can say that they do not consent to their entry and ask them to leave. And just as with any other situation, they can also exercise their right to remain silent. And for example, if they have the red card for rights, they can slide that card under the door. Also, even before they ask for the warrant, they can ask for the officer to identify themselves, and you can ask to take down their identifying information. If after inspecting that warrant that it is valid, that they do have the correct address, they do have the name of someone who actually lives in that home or is located in that home, then in that moment, what we recommend is for only that person, the person that they are looking for, exit the home so that no one else comes or leaves the home. So only for that person to exit and then be able to comply with the arrest warrant. Now, if this is a search warrant, it would be a warrant that is saying that they are looking to search for something very specific and in very specific areas of the home. What that means is anything that is out in the open in those areas that they are looking for, like if they're looking for something in the kitchen, in the living room, or in a specific bedroom, anything that is out in the open is fair game for them. They can be able to look at anything that's out there. So anything that you would consider to be confidential or private that you don't want out in the open, having that stowed away, because they cannot be searching for anything that is not in plain view for them in that specific area. Even in those situations, even if they have a valid search warrant, they have a valid reason to be entering your home, you still have the right to remain silent. Right, so you don't have to speak to them. They can comply, they can execute their search warrant, do what it is that they need to do, but you do not have to speak to them. And you can still also give them the red card. So that is generally what might come up in a situation where they are trying to execute a either search warrant or arrest warrant in your home. At school, a lot of schools have taken up some different policies. A lot of the schools have either sent out communications on what it is that they would do. But generally, these officers shouldn't be entering schools unless they're being permitted by the school to enter for that reason. But if, for example, what might come up, someone is coming up to the school to pick up their child and they're not in the school building, but they're just outside. This would be similar to just being out in public. And if it's in that situation where you're being stopped by them in public, you still have the right to exercise your right to remain silent, and you can still ask, who are they? Do you have a warrant? Same situation applies where you can ask to inspect the warrant. If it's not a valid warrant, you can ask if you can walk away and you can say, this is not me. This is not my name on this document. Can I walk away? If they say yes, walk away slowly. I think in these kind of situations, people are going to be really, really scared and they want to get away as fast as possible. Running away is just going to give them reason to come after you because, okay, why are you running? You've got something to hide. Even if you have legal status, even if you are a US citizen, but you are afraid of these kind of encounters, running away is going to give them a reason to come after you. So as much as possible, remain calm and walk away if after saying that, oh, this is not a valid warrant, you ask if you can walk away. And if they say yes, you can walk away. You do not have to answer any more questions beyond that.
In that situation, say someone obviously is scared and they kind of start pacing away from the officer, does that give the officer authority to continue to ask you questions on the basis of it being suspicious?
It might just depend. At that point, that interaction should have ended. That's an entirely different situation where, they've already indicated that you could have left in that moment. They didn't have a valid reason to stop you. They might still use that as an excuse to arrest you, whether it's valid or not. That is a bit of a tricky situation. But even in that circumstance, we would definitely recommend people to just remain silent at that point and to not resist, because what can come up at that point is they may catch a charge for resisting arrest, and then that can escalate to something even more. I think the key here is to not run away from that encounter. If you are nervous and you tend to just want to be able to get away as fast as possible, walk, even if it's at a fast pace, but walk away as calmly as you can to minimize that risk of an escalated encounter.
And if I may just provide a tip from someone that kind of runs on anxiety sometimes for folks, to help you walk away maybe a little bit more calmly if you do find yourself in that situation is if you can try even just like maybe squeezing your arms and reminding yourself that you could walk even faster in the next block at once you're out of sight, and just remind yourself that you'll get through there and you just have to kind of hold composure for a little bit.
Yes. And also, I do want to point out that even though ICE is permitted to be in public places, they are not forbidden from being out in the open. That does not give them the right to arrest anyone. If they arrest someone, there either has to be a valid arrest warrant or they have reasonable suspicion that you committed some kind of violation of some type. And obviously, that can mean a lot of different things, especially with recent case changes. I know there was a case regarding the ICE raids going on in Southern California, and that left rather a difficult decision that did come down from the Supreme Court regarding racial profiling. But still, there are still obviously constitutional protections in place. And so there's still the standard of reasonable suspicion that they should be abiding by. But for that reason, ICE still has to comply with, they have to have a valid arrest warrant even then, and they can't just arrest anyone without any justification. How that employs in practice, obviously that can be very different, but understanding that I still has to comply with those policies is very important to keep in mind.
Okay. And then I have one question that might be a little silly. Is there a difference between being arrested and detained?
So sometimes the words can be interchangeable. Detained, I think, in this sense, comes more within immigration. So when we are hearing that ICE is picking people up and detaining them, meaning they arrested them in the sense of they got them in custody, transferred them to a facility. So the words can be interchangeable. As you can see, I use the words for like very interchangeably in that kind of a scenario. But generally, with an arrest, when we think about the word arrest, we do think about when, for example, law enforcement wants to put someone into their custody for either a criminal or maybe even a civil charge in that sense, or rather criminal charge. So it's the arrest is the act of detaining someone, so having someone in their custody. So really with immigration, with ICE, detaining might just be that they wanted to have someone in their custody while they investigate whether there are any charges against. So someone being caught in an ICE raid and then being placed in a facility, at that point, maybe they were detained because there aren't any charges. Afterwards, then yes, it might be that they were arrested because of some kind of charge that they picked up. But in this scope of field, I would say detain, we can use that word in any kind of circumstance because of the scenarios that we are looking at, where ICE is just coming, gathering, picking people up. We can use the word detain, and especially because where these individuals are being held are detention centers. So they're not necessarily jails or prisons, but we are using the term detention in that sense.
Okay. And can you share a little bit about what happens if someone is detained, they're taken to the detention centers? What can that process look like? And what are the step-by-step things that someone might be able to do throughout that process?
Yes. So if someone is detained, what might come up at first is the person might be asked if they're detained by ICE, for example. They may be asked, or actually they might not even be asked, what we recommend people doing in those situations if they have a fear of returning to their home country due to some kind of harm or fear of persecution that they would have. They should request a fear interview. They can say, I'm afraid to return to my country. That would trigger for these officers to conduct a credible fear interview if possible. But again, that should come up only if the person actually has a credible fear of returning to their home country. What comes up in these kind of situations is the person will probably be picked up, taken to a detention center, maybe somewhere far from home. They may be allowed to make a phone call of some kind to someone. At that point, we recommend that person have what we would consider a contact person, not necessarily an emergency contact person, but someone that they can contact that would be able to implement movement in their situation. So this would be someone who is aware of, okay, so this person just got picked up, they got detained, they're in a detention center. I need to contact so and so. I need to gather these documents that they have. This is someone that is in tune to this person's emergency planning of what to do in those kind of situations. Because what can come up is that maybe they're only allowed one phone call within the course of a few days. And so they want to be able to use that phone call wisely. So being able to get in touch with someone who knows, for example, where are that person's emergency documents in terms of any childcare planning, if they have any kids, if they have any pending applications with USCIS, if they have any supportive documentation to show that they're a member of the community or anything like that, any medical information that is pertinent to them should they be detained, any contact information for an immigration attorney if they have one. So having someone that they can contact who knows where all of these things are and how to be able to get things moving is important to have. When they are detained, what can also happen is they might be detained for a number of months unless there is some type of humanitarian reason for them to be released in that moment. For the most part, a lot of individuals are not going to be able to request a bond hearing if they're placed in California, specifically in detention centers that are what are called within the Ninth Circuit. So most commonly referring to detention centers like Adelanto or Desert View specifically. At 6 months, they can request what is called a Rodriguez bond hearing. But again, that only comes up at 6 months of having been detained. A lot of
Wow.
these bond hearings, which is basically requesting the court to be released while their case is pending, showing that they are able to either meet the monetary bond, that they are not a flight risk, that they have ties to the community, and they have an address to go to, and that person or that address that they're going to be going to can ensure that this person will be complying with all of their court dates.
6 months, that's a long time.
Yeah.
I have one question about the call that people are allowed to make. What happens if their contact doesn't answer? Does someone literally have one call available to them?
So I don't know if it's that they only have one call available to them. It might just be that they might only have like a limited time available for them to make a type of phone call. So they can try as best they can. This is a scenario that I can point out is if it does happen where this person is detained, as if they have some type of communication with a loved one. For example, if you happen to have an iPhone, have Find My iPhone or something like that, and you have your phone on you. If there's no way for you to get in touch with a loved one, if the loved one isn't able to actually answer their phone, but you're able to maybe track the location of that phone, you might not have your phone on you if you are detained, but it might be within the general vicinity, seeing like, okay, where is it that they took them? That might come up in that kind of a circumstance. It's scary to think of having to use tracking software on your phones to do that, but that might be one way to see, what's going on. So it might not be that they're only allowed one phone call. It might just be that they're allowed one phone call within a couple of hours or days or something like that. So as much as they can if they are allowed to make more phone calls to do that. If they can't get in touch with the one person, maybe having a second person, but for the most part, trying as much as possible to get in touch with that one person or just being in constant communication with a loved one. I know for our practice, if a loved one gets detained, usually the family reach out to a bunch of organizations because they were made aware very quickly, either because that person was able to call them right away, like, hey, this just happened, or someone was with them or witnessed what happened. And so those family members are able to kind of get the pieces moving to get in touch with organizations, try to get some kind of relief, right? Or some kind of consultation of some kind. So I don't think it's that they only get one phone call and that's it. It might just be that they're given a very small amount of time to be able to make a phone call, and they won't get that chance until either a few hours later or next day or days after. So if they aren't able to get in touch with someone in that moment, try the next available time that they can.
Okay. And then for clarification, is that call different than the request to work with an attorney?
It is a different type of phone call. So, what I can speak to in my experience, those individuals, in order for them to make a phone call, they might have to have funds on their name in order to, or in an account for them so they can be able to make these phone calls. And these are calls that are monitored for the facility to see what's going on with those phone calls. The difference with the legal phone calls is, for example, if I am given information about, hey, this person got picked up, they need a consultation, I will be calling the facility on a designated phone line where I am requesting a legal phone call with that person. And those calls are going to be confidential. It's either calling to schedule that confidential legal phone call or calling, emailing to request a confidential video conference. So the phone calls are very different. The detainee making a phone call is very different. That's going to be an open line monitor. There's no privacy involved. Whereas an attorney can actually make a phone call to schedule a confidential phone call. They're scheduled by the attorney, but the facility will initiate them on the platform provided or using the phone number provided.
Okay. For someone that might be in the midst of getting their documents within the US and they have been working with an attorney or maybe something like the Public Law Center, are those the key contacts that they should be connecting with when they are detained?
So we would definitely recommend having someone who is not the attorney being like the top contact, because understandably some attorneys might not have access to their phones 24/7, or they have very designated lines, or just because of the nature of caseloads, they might not be readily available. But it is important to have that attorney's contact information. So if someone is in the process of getting papers, of filing something with either immigration court or with USCIS, U.S. Citizenship and Immigration Services. Having that attorney's contact information is important, because if that person is detained and they're able to make that call to a loved one, their top emergency contact, that person can then get in touch with the attorney like, hey, this just happened, or this is what's going on. And then the attorney can then take steps in place to be able to get things moving forward. So some clients of ours, or in general, what might happen is the attorney finds out and then they're calling the facility, getting in touch with them, trying to figure out what's going on, also trying to figure out what are the conditions that they're being held in, just to try to see what's going on. Because what can also happen is if the person is detained and they're being held in inhumane conditions, or there are other mitigating circumstances or factors to warrant them being released, they can do some type of petition to get them released, aside from the 6-month bond hearing that can come up later down the line. But yes, generally what we recommend is having that attorney's contact information available so that your emergency contact then knows to get in touch with that attorney.
Okay. So it seems like it's very important to have one person that can help put all the people together, gather information, that type of thing. What are some other best practices that people can prepare ahead of time? I know there's a lot of talk around like preparedness plans. Can you share a little bit more about that?
Yeah, so aside from having that trusted member if this person has been in the country for more than 2 years, putting together any documents that showcase that, because in general, they should not be a deportation priority because they've been in the country for more than 2 years. Any type of documentation to show ties to the community or anything that would show, for example, if they were to leave, they suffer any substantial harm in home country, or any of their children would suffer substantial harm. Speaking of children, if they do have kids, having a type of document which is called the caregiver affidavit. It's a document that someone that they trust can have pre-filled out that shows that this person is authorized to take any education decisions or provide any information to a doctor's office, and they can sign in the moment that they're going to execute it. This is different from what some people might consider a power of attorney. For child care purposes, caregiving purposes for children, a power of attorney is not sufficient in the state of California. And we can hear that very often, especially in Spanish-speaking communities, about a carta de poder. That is not an effective tool. What would be best implemented in that case is obviously a caregiver affidavit is limited to school and doctor and medical purposes. What a parent can do in that case is draft a letter, even if it's in their own handwriting, but they can draft a letter outlining this is the person we are authorizing to make these decisions for our child in the case of something happening. And it has to be signed by you. At that point, that is a valid document because it is your wills, your wishes, your signature. If you feel a bit more comfortable wanting to be a bit more official, you can take that document to be notarized by a notary public. There are new laws in place, especially given the circumstances that are going on with children. So definitely looking more further into that with these documents to have in place any kind of information that will be helpful in your case. For example, if you are detained, having proof of, where it is that you would be staying, who would be responsible with paying the bond, the monetary amount that they would be putting in place in order for you to be released, any kind of letters of support showing if you are not a flight risk, so that you're not a danger to the community, that you're not going to flee, any letters of support saying that they will be providing support to make sure you attend all your immigration hearings and things like that. If the person is in the process of obtaining legal status, or if they filed something, having, for example, receipt notices put together in that sense to show like, hey, this application is pending, or this is the last action taken in this case. So that's what we mean by having documents put together and ready, kind of having that kind of emergency preparedness plan. Also, something very important is informing your family of what to do. For example, the best defense is being informed, being aware. So like I mentioned, when you're home and ICE comes to your home and knocks on the door, all it takes is for one person to just open that door, and that invites them in, essentially. So informing your family members, hey, these are our rights. If it ever comes up where someone knocks on your door, we don't have to open the door. We don't have to let them in. We have rights. So every member of your household being informed of their rights is a way to be able to be prepared, and understanding, hey, if this happens where I'm detained for whatever reason, you can go to this person. They're going to know what to do. They know where these documents are being held. Being informed with your family of what your plan is, should that ever come up. And then documentation to have on you, like we discussed before, having your ID, any proof of a pending application, maybe having a copy, but again, only having that on your person and only presenting it if you are asked at any point about that, not presenting it willingly and offering it up, essentially.
Thank you for sharing those tips. And for folks that might be considering doing some type of legal filings, either for their green card or for their citizenship, I know this might be a little bit different on a case-by-case basis, but would you be able to share some of the things for people to consider about either of these filings during this time?
Yeah, so if people are considering some kind of filing, first and foremost, obviously obtain a consultation with an immigration attorney to evaluate the strength and validity of your situation. And in that respect, the reason for that is so that you understand, what are the risks in filing an application, what can come up. Big thing to note, if you have any kind of criminal history, going to an immigration attorney who is aware of criminal situations so that they can advise you of what are the risks of moving forward with certain things. Or if you have a criminal history, how that can affect your immigration case moving forward. It might involve the attorney advising you then at that point to seek some kind of post-conviction relief so that any prior convictions can be reduced to something lesser so that there are less harsher immigration consequences. In that sense, that way you know kind of, what is going on in your situation, what's happening, what might put you at risk. Also, with a lot of these filings, there have been changes in fees. Not per se the application itself has difference in fees. Some of them have changed, but a lot of these applications now have what we would consider like administrative fees or processing fees, additional fees. So understanding that some of these fees might be a little bit more costly. A big change also has come up is USCIS is no longer going to accept any money orders or cashier's checks to pay for a lot of these filing fees. So having either a credit card available or a bank account available because you'll have to do some type of electronic payment at that point. Big distinction. People should be going to an immigration attorney or at the very least a Department of Justice accredited representative. People in communities might be inclined to go to a notary public, commonly known in especially Spanish speaking communities, notarios. Notary publics are not immigration attorneys. They are not authorized to practice law. The most that a notary public can do is just authenticate and validate that the person appearing before them is the person on the identification that they're providing and the person signing before them. They have to be either a Department of Justice accredited representative, which you can find that information online, or a licensed attorney either in California or in any other state. For immigration purposes, the attorney doesn't have to be licensed in California. They can be licensed in another state because immigration is a federal. But for anything that is state-wise, so for example, any criminal convictions or anything like that should be a California licensed attorney. But again, you can find their information online. You should be able to find their information online. But yes, first and foremost, to seek a consultation, evaluation with an attorney, and understanding what the risks are involved, having the filing fees available and ready to be able to pay them when the time comes, and just gathering any information, any evidence that would help with their cases. Again, instructed by the attorney, they'll be able to tell them, what information you should have, and always maintaining your contact information updated. So that way, either the attorney or USCIS, when you do eventually file, know how to get in touch with you in that sense. A lot of the times, a lot of these cases take many, many years to process. Like I'm already thinking about a U visa, for example, those can take many years before they're fully adjudicated and decided on. So maintaining your contact information current with the attorney so that they know how to get in touch with you if, for example, you get a request for evidence, the USCIS wants more information about something, or in the good chance that they made a bona fide determination, a preliminary review of your application, and they determined that you are filing this in good faith, and it seems that you may be eligible for the U visa, and they issue you a work permit or that kind of a determination for you to be able to get those documents. So always maintaining open communication with the attorney, updating your information when the time comes, and having that constant communication with your attorney.
Okay. And going back to the notario piece, can you share why is it so important to be able to be represented by an immigration attorney during these filings?
Yes. So what's very common, especially in a lot of Latin American communities, is in a lot of their home countries, a notario is an attorney, essentially. They are licensed to practice law. In California, specifically, notary publics are not licensed to practice law. And legally, they are not allowed to call themselves notarios. So for that reason, a notary public is not going to be the person going with you to your interview, for example. They're not going to be able to defend you in that kind of situation. They don't have the authority to do that. And so they are not going to be able to back your application for you. Whereas an immigration attorney, they're going to understand why you did something with your application, why it is that you're moving forward with this. They'll understand, if they hit a snag in terms of, oh, the agency made this negative decision in your case, they'll know how to argue that. And Notary Public is not going to be able to do that.
Okay. Thank you for that and sharing what each of them might be useful for. And they each have their own roles, but there is a distinction in working with both of those. And taking a little bit of a bird's eye view in terms of policies impacting the immigration space right now, can you share a little bit of the top ones that maybe public law center is looking at, as well as other advocates in the immigrant community space?
Yeah, so I know the first one that comes to mind for sure is the alien registration requirement, or what people were hearing about early in the year. So that is a big one that came up, and it did go into effect as of April 11th, 2025. And so what that is asking is for anyone who does not hold legal status of some kind to register with USCIS specifically, to indicate their status or their lack thereof. And this is different. There is something called the registry that's something completely different, but this alien registration requirement essentially is asking for people to register that they exist within the United States. Otherwise, they can face not just administrative issues, but also criminal charges. There is that threat. So individuals should absolutely consult with an attorney at that point to see if they are required to register. Some people might already be registered. Green card holders, because they are a green card holder, they are registered. Someone who has DACA is already also registered. If you have a U visa, you are already registered. So there are certain statuses that indicate that you are technically registered, so you don't have to do anything further with that. But if you are not, definitely checking with a immigration attorney to find out if you are required to register, and also understanding what the consequences might be if you do not register. Another big thing that I know came up recently that people were hearing in the news was the decision in Texas regarding DACA. So there were rumors that DACA, any initial application, so people who have applied for DACA for the first time, or maybe they lost DACA status and now they're applying for it all over again, those initial applications are still on pause. So people can still submit their applications, but they are not being adjudicated yet. Renewals are still in effect. So people should move forward with the renewals if they can. And speaking of renewals, the most recent decision that came down, or the most notification that came down, was this discussion of automatic extension of employment authorization documents, or EADs, also known as work permits. There are certain applications where if your work permit expired, but you were in the process of renewing your work permit, you would get an automatic extension. Now that has been eliminated. We know that it'll have a big impact in the next coming weeks and months, especially. But if people do have to renew their work permits, recommending that they file those within the 180 days of the expiration so that they are processed timely. So I know that's one of the more recent notifications that came down. So just being mindful of keeping an eye on when those work permits expire and filing those renewals in a timely fashion. Also, what we have heard, or something that is important for people to know and understand, that there was discussion of information sharing between ICE and the IRS. So that can be very intimidating, especially the thought of, if you have an ITIN, IRS tax identification number, what's going to happen to you? So yes, ICE and the IRS can share information. The IRS can share information with ICE. However, they're not sharing everyone's information all at once. What ICE has to do is submit a request for someone's information specifically, and then the IRS can provide that information. And this usually only comes up for individuals that are facing final removal orders or are under federal criminal investigation. So there are very specific circumstances that they are sharing this information. But again, ICE has to formally request someone specific in order to get that information. They are not going to get everybody's information at once. They have to still follow protocol with requesting information through a formal process. And also something that might come up is for individuals that entered on the CBP-1 app, so the parole application in order to enter the US, that has now been redesigned into CBP Home. And some people might be receiving self-deportation alerts or messages. They should not take any action on those. We were
Hmm.
hearing at the time when CBP-1 changed to CBP Home that people were receiving alerts because they used that app originally to enter the US on parole of some kind. We recommend that people consult with an attorney first before taking any kind of action, because self-deportation might cause further immigration consequences down the line. Also, something that we have seen come up recently is changes with ICE check-ins, or what's also called as ISAP in some other circumstances. Definitely recommending that people talk to their attorney if they do have one, to ask, what's going on with it. It's a little bit up in the air, but some people have discussed that they are making changes to how these check-ins are being done, either having to do ankle monitoring or more frequent check-ins at an ICE, USCIS office, ICE office at some kind. So definitely following up with your attorney if you have one, to find out, what are the changed circumstances, what's happening, what's going on, what should they expect. With our office personally, for some of our clients who do have to do any kind of check-in, we do try to go with them together just to see, how these circumstances are going on, if they're being detained or anything like that, so that we know exactly what's happening on the ground. So if people are concerned, definitely checking in with their attorney so that they can either have the attorney go with them or coordinate someone to go with them to these kind of check-ins, and also just to stay abreast of like any changes that are coming up.
Okay. Wow, that was a lot of information. Are there any other things that you want to share with folks that I didn't ask and maybe you think would be really like helpful and important for people to know?
I do want to bring up a scenario that might come up. We've discussed, what to do if ICE comes to your home or they approach you in public. Another scenario that can come up is, what if ICE goes to your work? ICE has to have a valid arrest or search warrant in order to arrest someone on those premises. But they can be permitted on those premises by the employer or by the owner of the business. Even in those situations, again, as nervous as you might be, don't run away, remain as calm as possible, and only interact with them if it is that they are looking for you specifically. But again, in those circumstances, ask, do you have a valid warrant? This is, if it's not your name on it, this is not me. This is not my name. My name is this. Just identify yourself and move on. Those same instructions apply as if, if you're home or in public, asked to inspect the warrant. If it says it's coming from a court, if it's signed by a judge, if it has your name and the date and time that's to be executed, it's a valid warrant, and then exercise your right to remain silent. But again, even in a business or any in your job or any location, there might be areas that it says that are not open to the public. ICE cannot go to those areas. So you might notice there might be offices that say authorized personnel only. If it is permitted, and that is an area you are allowed to be in, staying in those private areas, ICE cannot go into those areas unless they're given authorization by someone higher up in your place of business. Also, for community members, especially if you are out in public and you do see that there is something going on, that there's ICE raids happening. And most importantly, for any person, do not lie, do not run, do not physically resist. Ask ICE if they have a warrant, but also, especially for people who are maybe in a more privileged position to not have to fear being arrested, you can record the encounter, but obviously there is documentation etiquette to keep in mind. You cannot interfere with the situation or with the arrest. You have to stay at a certain distance, at a safe distance, but you can record. You do have to announce that you are recording so that ICE is aware and everyone is aware that there is recording going on. Record the agents, don't necessarily record the individuals, but record the actions of the agents. Note the date and time of this encounter, how many officers are there, did they say who they were, or did they say why they were there? The officers might say, like, hey, you have to not record, you're interfering. As long as you're in a safe distance and you're not actually up in their faces, you can still record, again, as long as you're not interfering. But again, only if you feel safe to do so. And if you don't feel safe to do so, still remember these details, remember all these details so that you know kind of how to use those details in the future in your case. For example, if this was a violent arrest of some kind.
And in terms of the interfering, does following officers count as interfering?
It can to a degree, but again, that's why it's important to keep a safe distance for them, so that it shows that you're not interfering. We don't recommend following officers because that can then be turned against you in that kind of a situation.
More questions just came up as you started sharing. I know there are rapid response networks. Is that something you have familiarity with and that you could speak to a little bit?
Yeah, so in Orange County, there is the Orange County Rapid Response Network, and these are advocates that are notified when there's an ICE raid going on, so they can go and see what's going on in those situations. So their purpose is to respond and protect community members from immigration enforcement activities. And if people do see ICE, we do have their contact information. So it is a phone number that people can call. It's more for to have advocates on the ground and seeing if there's any way that they can help people if that's what's going on, or kind of see what exactly is happening in those situations.
Okay. And I know many other communities also have rapid response networks. So if it's
Exactly.
something people want to look a little bit more into. But Leasly, thank you so much again. And can you share a little bit about where people can find you, what information they might be able to find on the Public Law Center's website, and any other resources where people can find some resources to create the preparedness plans and find the red cards that we talked about earlier?
Yes, of course. So, Public Law Center is a nonprofit legal services organization based in Santa Ana, and we do serve Orange County residents. And we do have different areas of law. So, just to kind of give a brief overview, we have consumer law, family law, health, housing, immigration, of course, and small business nonprofit. We do have more information on our website, www.publiclawcenter.org. To be able to get information from any of our units, they can call our general phone number, which is 714-541-1010, or they can email us at info@publiclawcenter.org. If they do wish to get in touch with the immigration unit specifically to schedule consultation, our extension is an automated voice line, but they can call and leave a message with their name, contact info, and what it is that they're looking for. And so again, our phone number would be 714-541-1010, extension 332. And in terms of other kinds of immigration resources, the Immigrant Legal Resource Center, ILRC, has a lot of know your rights information and preparedness packets available, as well as ways to download the red cards. If people are looking, for example, for advocates within their own areas, there is the Immigration Advocates website, which is www.immigrationadvocates.org/legal directory. And that's a website where people can enter their zip code, their state, or the city, and it'll bring up a list of organizations within their area and the areas of immigration that they specialize in or that they work in. So they could be any type of affirmative immigration forms of relief, which would be like U visas, DACA, adjustment of status, things like that, or removal defense, for example. So those are resources that we definitely recommend people going to get more information, especially, and as well as information about Public Law Center as well.
Okay. And for folks who might be driving, might not have a pen, pencil, all of those links will be in the show notes as well, or listen to the recording again as well. All up to you. But thank you, Leasly, so much for joining me today. And I hope folks feel a little bit more prepared for how to navigate some of these what if scenarios. And if you got at least one thing out of today's episode, I would greatly appreciate if you took a moment to write a review and maybe even share the episode with at least one friend. All right, bye. Thank you for joining me for another episode of Rooted in Intention. Until next time, and remember to keep showing up for the life, relationships, and community you want. Now go, grow the life you want